Good evening, everyone. And whenever Justice Kuldip Singh, a former judge of Punjab and Haryana High Court, comes, it always gives a pleasure because it gives and relives our memory to the effect that when we were appearing before him. We have always read the judgment of Satendra Kumar Antil versus CBI, wherein various directions had been issued, and consequently, this session of today, as I discussed with Justice Kuldip Singh, he has said that he will take these facets into different aspects and divide the same. And as usual, we expect that it will be crisp as his judgments were. His grasp over the law, you all know that he immediately used to grasp any aspect and thereafter deliver the judgments. Therefore, to understand the aspects of right of bail, directions which have been issued to the different authorities, in consonance with sync with Article 21 of the Constitution of India, and right to speedy trial, and a large number of aspects which have been dealt with this judgment, which we can say is quite path-breaking. And the passion of Justice Kuldip Singh to share his knowledge can be seen that this judgment came much after he had demitted the office. But he said that this judgment, as a common man also, quite fascinates him because there are different aspects which are required to be shared with the public at large so that the points are hammered well within everyone to understand. Without taking much time, we will request Sir share his knowledge, and thank you for accepting our invite for sharing your knowledge. Over to you, sir.
Good evening, everybody. Nowadays, the problem of general public is that whenever, unluckily, they are got involved in a criminal case, they have to face a trauma. They have to go through different procedures, and many times they feel that the justice has not been done to them. Probably the provisions of the law as contained in the Constitution of India and the Code of Criminal Procedure are not followed in letter and spirit by the authorities and sometimes by the judges also. So here comes the judgment, Satendra Kumar Antil, where the Supreme Court has taken the lead in thrashing all the aspects of the arrest, grant of bail, right of speedy trial, and giving direction to the various authorities, that is the police and the judiciary, to follow it. So we can divide this into 6 aspects. First is the prevailing situation in the jails. Second is the arrest. Third is bail. Fourth is the right of speedy trial. Then the directions. And then the last but not the least is the implementation aspect of this judgment. As we know, the jails in India are flooded with under-trial prisoners. It is indicated that more than 2/3 of the inmates of the prison constitute under-trial prisoners. Of this category of prisoner, majority may not even be required to be arrested despite registration of a cognizable offense, being charged with the offenses punishable for 7 years or less. They are not only poor but illiterate, but would also include the women. For them, for whom there is a special provision in the CRPC for grant of bail. The Supreme Court has observed that it exhibits the mindset, vestige of colonial India on the part of the investigating agency, notwithstanding the fact that arrest is a draconian measure resulting in curtailment of liberty and thus to be used sparingly. In democracy, there can never be an impression that it is a police state, as both are conceptually opposite to each other. So considering that 2/3 of the under trial inmates are the under trials. One is to go through the definition of trial. In CRPC, the definition of trial is nowhere given. But the apex court observed that for the purpose of bail, an extended meaning has to be given to include the stage of investigation also. Now, the arrest is to be made under section 41 of the Code of Criminal Procedure. It is not that once a case is registered, a person is to be automatically registered. There are certain provisions which have to be followed, and unluckily, which are not being followed. So the apex court reproduced section 41 of the CRPC in the judgment. It says, section 41 says that when any police officer may, without any order from the magistrate and without a warrant, arrest any person who has committed a cognizable offence or against whom there is a credible information or reasonable suspicion exists that he has committed the cognizable offence, punishable with a term which may be less than 7 years or which may extend to 7 years. If the following conditions are satisfied, that means for arrest, the conditions, if the sentence is up to 7 years, the following conditions have to be satisfied. The police officer has reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offence. That is his satisfaction. The police officer is satisfied that the arrest is necessary. It is not that in every case arrest is to be made. Other is to prevent such person from committing any further offence, or it is for the proper investigation of the offence. Then to prevent the person from causing the evidence of the offence to disappear or tampering with such evidence, or prevent such person from making any inducement, threat or promise to the person acquainted with the facts of the case, or dissuading him from deposing in the court. Unless such person is arrested, his presence in the court, whenever is required, cannot be ensured. That means if the officer feels that his presence in the court cannot be ensured, so he can arrest them. Then the section says the police officer shall record while making such arrest his reason in writing. That means if the offence is sentence is up to 7 years and the arrest is to be made, and the police officer has to record his reason that one of the above noted clauses are satisfied. In the case where the sentence is more than 7 years goes up to death sentence, the police officer can arrest a person if he is a proclaimed offender, there is a credible evidence against him, then he is in possession of stolen property or obstruct the police officer while executing the duty, or he is deserted from the army, and so and so. It says if no person concerned in non-covenant offence or against whom a complaint has been made or credible information has been made, receipt or reasons in which have been shall be arrested except under the warrant of the magistrate. So, in case the sentence is more than 7 years, person can be arrested, and if the police officer decide not to arrest, he has to record the reason that the arrest is not necessary. So, even for the serious offences, he has to see whether the requirements of the section 41 are met. Only then the arrest is to be made. It is not that in every case arrest is to be made. Then there is section 41A. That is a notice of appearance for the police officer. Whenever a case is registered, the police officer will issue a notice to the person against whom a reasonable complaint has been made or credible information received, etc., etc., to appear before him at such person, then such person is required to appear at the said time and place mentioned in the notice. If such person complies and continue to comply with the notice, he shall not be arrested. Section 41A says, if the person continue to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice, unless for reason to be recorded, the police officer is of the opinion that he ought to be arrested. Further, where such person at any time fail to comply with the term of the notice or is unwilling to identify himself, the police officer may, subject to such order as may have been passed by a competent court in this behalf, arrest him. So all the rest have to be made in accordance with section 41 and 41A. No, in case of courts, the procedure is contained in section 87 and 88. The examiner, the section shows that in the initial, the court is not to jump to issue the warrants at the first stage. Court is to issue summon at the first instance. And if the person doesn't appear or is avoiding, only then the bail runs, and if he fail to comply the bail runs, only then the non-bail ones are to be issued. And then when a person appears, whether on a summons or warrants, the bonds are to be taken for his appearance. The Supreme Court has also observed that there are sufficient safeguards in the CRPC itself, which are unluckily ignored many times. Supreme Court referred to section 167(2) of the Code of Criminal Procedure, which says that when a person is arrested, he has to be forwarded to the magistrate within 24 hours having the jurisdiction. The magistrate can authorize the detention of a person for a maximum period of 15 days. But such a detention cannot exceed 90 days in case the punishment is 10 years or more, extending up to life or death, and 60 days in other cases, in case the sentence is less than 10 years. So the overall period of detention cannot exceed 60 days or 90 days. After that, if the police report is not presented, the person has to be released on bail. For the purpose of authorizing detention, for the first time, the person has to be produced in custody before the court. And for the judicial custody, he can be produced through medium of electronic video linkage. So that is it. Then there is another section which is commonly misinterpreted. That is section 170 of the code. It says, if upon an investigation under this chapter, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground, as aforesaid, such person shall forward the accused under custody. What is under custody? To the magistrate, empowered to take cognizance of the offence upon a police report and to try the accused or commit him for trial, or if the offence is bailable and the accused is able to give security, shall take security from him for his appearance before such magistrate on a day fixed for his attendance. So the word custody, there has been, I will subsequently come to judgment. Custody doesn't mean that it must be in the police custody or in judicial custody. Custody has been liberally interpreted to denote the presence of the person, his physical presence, not actually in police or judicial custody. So then there are section 2004 and 2009 where the process has to be issued. Then there is another important section which has been largely ignored by the courts. That is to prevent the unnecessary custody or detention of the accused. That is section 309. That is a power to postpone or adjourn the proceedings. I will read out that section, what it actually says. That is also incorporated in the judgment of the Supreme Court. In every inquiry or trial, the proceeding shall continue from day to day unless all the witnesses in attendance have been examined, unless the court find the adjournment of the same beyond the following day to be necessary for the reason to be recorded. That means day-to-day trial is the rule and adjournment is exception. Whereas now what we say that the adjournment has become a rule and day-to-day trial is an exception. The section further talks about section 376A, A, B, B, 370, C, D, B, A, and where the trial has to be completed within 2 months from the date of filing of the charge sheet. This section further says that if after taking cognizance of the offence or commencing trial, the court find it advisable or necessary to postpone the commencement of the or adjourn any inquiry or trial from time to time for reason to be recorded, postpone or adjourn the same on such term as think fit, as it considered necessary, and may by a warrant remand the accused in custody. Then there is a bar that magistrate cannot remand the accused in custody for a term exceeding 15 days. This section further says that when the witnesses are in attendance, no adjournment and postpone shall be granted without examining them, except for special reason to be recorded in writing. It further provides that no adjournment shall be granted for the purpose only of enabling the accused person to show cause against the sentence proposed to be imposed upon him. I had observed during my service that in the many courts, particularly in Haryana, there is a tendency that while pronouncing judgment, the person is convicted, he is taken into custody, and the adjournment of 1 week or 10 days is granted for hearing on the sentence. That is against the, the section 309. No adjournment is to be granted for showing the sentence proposed to be imposed upon him. So that court needs to be sanitized about this section. During my service, I had passed a judgment giving various direction to the courts incorporated in section 309. I hope these are being followed by the courts. Then we'll see that even after conviction, the man is not to be arrested. He has to be granted bail. Then there is section 389, where the sentence is up to 3 years and conviction is a magistrate. The accused is ready to deposit the fine. The magistrate has to release him on bail to enable him to file the appeal. Of course, the appellate court, for reason to be recorded writing, suspend the sentence even after conviction. The session court and the high court can exercise these powers in case where the sentence is serious, that death or imprisonment of life or sentence of not less than 10 years. The opportunity has to be given to the public prosecutor for showing cause against the accused. So we have to see that even after the conviction, the tendency is that in the minor cases where the sentence is minor, he is to be released by the trial court itself. Where the sentence is serious, the sentence is to be suspended. Can be suspended by the session court or the high court. Now we have to notice that presumption of innocence is attached with the accused. it is widely recognized under the Universal Declaration of Human Rights, Article 11, and then Article 14.2 of the International Covenant on Civil and Political Rights. In Arnesh Kumar versus State of Bihar in 2014, the scope of section 40 and 41 and 41A was examined by the Supreme Court. In Arnesh Kumar's case, the Supreme Court had found out that arrest is not to be made straightaway. The arresting officer has to put a question to himself. Why arrest? Why it is really required? What purpose it will serve? What object it will achieve? So in that case, the Supreme Court had observed, it is also incorporated in the Satendra Kumar judgment, that our endeavor in this judgment is to ensure that the police officer do not arrest the accused unnecessarily and the magistrate do not authorize the detention casually and mechanically. In order to ensure what we have observed, we are giving the following directions. In Arnesh Kumar's case, certain directions were given. All the state governments to instruct the police officer not to automatically arrest when a case under section 49A IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down above flowing from section 41 CRPC. All the police officers to be provided with a checklist containing specified subclasses under section 41, 1B, subclass 2. So the checklist is there, the direction was there, the checklist is there. They have to see that whether the accused, before arresting, whether he meets the parameters laid down in section 41, and he has to record the reasons. The checklist has to be duly filled and furnish the reason and material which necessitated the arrest, while forwarding the accused before magistrate for further attention. Then it was the requirement that the checklist should be there and it is filled in and forwarded to magistrate. Then further duty was imposed upon the magistrate in the said judgment. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in term of aforesaid, and only after recording its satisfaction, the magistrate will authorize the detention. So the magistrate is not to mechanically authorize the detention of the accused in either in the police custody or judicial custody. He is to see the grounds mentioned in the checklist, whether the arrest was necessary or not. So the decision not to arrest the accused has to be forwarded to the magistrate within 2 weeks from the date of institution of the case, with a copy to the magistrate, which may be extended by the SP of the district for reason to be recorded. Then it further says that in case of notice under section 41A is to be served for a period within 2 weeks from the date of issuing the case, it can be extended by superintendent of the police. The court gave very strict instructions in Arnesh Kumar's case that failure to comply with the direction of aforesaid shall, apart from rendering the police officer concerned liable for departmental action, they shall also be liable to be punished by way of contempt of court to be instituted before the High Court having territorial jurisdiction. That was against the police officers. And against the judicial officers, it says, authorizing the detention without recording reason aforesaid by judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. Then further that this direction doesn't apply in cases under section 498A or section 4 of the Dowry Prohibition Act, but also such cases where the offense is punishable with a term which may be less than 7 years or which may extend to 7 years with or without fine. So these directions were issued way back in the year 2014 in Ramesh Kumar's case by the Supreme Court. And in case of failure to comply with the direction, the action is to be taken against the police officer and the magistrate. Then we have to examine that the non-waiver bonds are not to be issued in routine. Section, then there are section 53 under the CRPC, in the first instance court is to issue summon or bail bonds, or if the accused is not arrested or is avoiding or on certain ground, it can issue non-bail bonds also. Same procedure is to be followed in the complaint cases filed before the courts. Then the Supreme Court also discussed another celebrated case of Siddharth versus State of UP. The judgment is, it is 2021, 1 SEC 676. It talks of section 170. It says in case where the prosecution doesn't require the custody of the accused, there is no need for an arrest when the case is sent to the magistrate under section 170 of the code. There is not even a need for filing the bail application as the accused is merely forwarded to the court for the purpose of framing of charge and for issuance of process for trial. If the court is of the view that there is no need for any remand, then the court can fall back upon section 88 of the code and complete the formalities required to secure his presence for the commencement of the trial. Of course, there can be situation where a remand may be required. It is only in such cases that the accused will be heard. And in such a situation, an opportunity will have to be given to the accused person if the court is of prima facie view that the remand would be required. So the court made clear that it is not applicable to the person accused who are already in custody, for which the bail application has to be decided on merits. So many times it happens that the police completes the investigation and present the challan, doesn't arrest the accused. So there it says even the bail application is not required. The purpose of the bail is merely to secure the presence of the accused before the court. It is not to punish him. He is not to be kept in custody as a punishment. I will discuss it in the later part. In High Court of Delhi versus CBI, the court discussed that word custody appearing in this section does not contemplate, that is 170, section 170 CRPC, doesn't contemplate either the police or judicial custody. It merely connotes the presence of the accused by investigating officer before the court at the time of filing of the charge sheet, whereafter the role of the court starts. Had it not been so, the investigating officer would not have been vested with the powers to release a person on bail in a bail offense after finding that there was sufficient evidence to put the accused on trial, and it would have been obligatory upon him to produce such accused in custody before the magistrate for being released on bail by the court. So, in case of High Court of Delhi versus CBI, it was held that it is not necessary that accused should be produced in custody in all the cases. in this case, it was also observed that in normal and ordinary course, the police should always avoid arresting a person and sending him to jail. If it is possible for the police to complete the investigation without his arrest, and if every kind of cooperation is provided by the accused to investigate to the investigating officer in completing the investigation, it is only in case of utmost necessity where investigation cannot be completed without arresting the person. For instance, person may be required for recovery of incriminating articles, weapon offense, eliciting some information, or clue regarding his accomplice, that is, arrest may be required. But ordinarily, it is not that the person is to straightway arrested. So the High Court, the Supreme Court has observed in said case that it is not essential that in every case, the involving cognizable and non-bailable cases, that the accused has to be taken to custody when the charge sheet or final report is filed. Then there are very, important observations made by the Supreme Court in this case. It says that usually we have noticed that the trend is that the person is released on bail on furnishing personal bond or surety of some amount, say in few thousand to lakhs. So the Supreme Court examined this aspect, whether that monetary loss is sufficient to prevent the accused from fleeing from justice. It observed that it is high time that our parliament realizes that the risk of monetary loss is not the only deterrent against fleeing from justice, but there are other factors which act as equal deterrence against fleeing. So except the monetary loss, there are other facts which probably escaped the notice of our lawmakers. That will also prevent. That is, such as family ties. A person may be well settled in the family, so it is not possible to abandon your family and run away. Roots in the community, job security, membership of stable organization. These are some of the facts which have to be considered as a deterrent against the accused from fleeing from justice. The court observed that the length of his residence in the community, his employment status, history, and his financial condition, his family ties and relationship, his reputation, character, and monetary condition, his prior criminal record, including any record of prior release on cognizable offenses or bail, the identity of the responsible member of the community who would vouch for his reliability, the nature of the offense charged, and apparent probability of conviction and likely sentence which may be passed against him are the relevant facts to be considered to seek the risk, to examine the risk of non-appearance. Again, the purpose of the bail is only to ensure the presence of the accused during trial and not to punish him. The court is to see whether after considering these facts, there is a risk that accused will not appear before the court. Of course, if the court is satisfied on these grounds, the accused has to be released on bail. Then there can be circumstances of a major risk where the man is of notorious character, confirmed criminal, court may insist on bail and sureties. Of course, where the person is hardened criminal and the court is satisfied that is likely to flee from justice, considering the seriousness of the offense, then of course the court can record the reason and decline to release him on bail. Now I will come to the bail aspect as examined by the Supreme Court after considering and examining various sections. There is a little notice section 436A of the code, which considered the maximum period under which a trial can be kept in custody. It says where a person has during the period of investigation, inquiry or trial under the code of an offense under any law, not being an offense punishable with death, undergoes detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under the law, he shall be released by the court on his personal bond without sureties. Of course, there can be ground where after hearing the public prosecutor and recording reason, his detention can be continued for a period longer than 1/2. But there is a further writer that such detention cannot exceed the maximum period of imprisonment provided for that offense under the law. We have noticed that many times the people have undergone the imprisonment which is more than the punishment provided for the offense. So for that, section 436A is very useful. So the under trial cannot be kept in custody for indefinite period. Then we daily examine the provision regarding the bail, section 437. We'll see that the tendency is that unless it is absolutely necessary, the person should be released on bail. It says, when any person accused or suspected of commission of any non-bail offence is arrested or detained without warrant by an officer in charge of the police station, or appears or is brought before the court other than the High Court or Court of Session, that means the Court of Magistrate, he may be released on bail, but the rule is he may be released on bail, but such person shall not be so released if there appears reasonable ground for believing that he has been guilty of offence punishable with death or imprisonment for life. The person shall not be released if such offence is a cognizable offence and he has been previously convicted of the offence punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted on 2 or more occasions of cognizable offence punishable with imprisonment for 3 years or more, but not less than 7 years. So unless these grounds are there, the magistrate has to release that man on bail. Further, it says that if in the said clause 1 and 2, the person is under the age of 16 years, woman or sick or infirm person, so that he has also to be released on bail. Of course, the bail can be declined for the special reasons. It further says that the mere fact that the accused person may be required for being identified the witnesses during investigations shall not be sufficient ground for refusing to grant the bail if he is otherwise entitled. Provided also that no person, if the offence alleged to have been committed by him is punishable with death, imprisonment for life, or imprisonment for 7 years or more, may be released on bail by the court under the section without giving any opportunity of hearing to the public prosecutor. Then there is subsection 2, that if the further investigation is to be conducted, the man has to be released on bail. Then subsection 3 says that when a person accused or suspected of commission of an offence, punishable with imprisonment which may extend to 7 years, that is the second category, comes to extend to 7 years. Or more, then certain conditions has to be imposed that he will not directly and indirectly induce, given in threat to the witness, he will not commit the similar offence or tamper with the evidence. Then the power is also there with the court granting the bail to cancel the same. The power of bail are also vested in the High Court and Court of Session under Section 439 CRPC. Everybody is well aware of that. That is therefore I will skip that. Sometime what happens that the court granting the bail impose a condition demanding a bond which is excessive. Then under Section 440, this can be, the amount of bail bond can be reduced. So the Supreme Court in this case categorized the offences for the purpose of bail. So it will make convenient for the courts to consider the grant of bail. The first category is category A, where the offence is punishable with imprisonment of 7 years or less. But doesn't fall in other category B and D. Then category B is the more serious cases where the sentence is more than 7 years or life imprisonment or death. Then category C are the special act containing stringent provision for bail like NDPS, PMLA, UAPA and Companies Act. Then the D category are the economic offences not covered by the special act. So the Honorable Supreme Court has discussed the category wise. In the category A, the summons are to be issued. Of course, regarding the bail, I've discussed above. The normal is that the bail is to be granted unless there are special reason for declining the same. And the warrants are not to be issued at the first instance, first the summons, then bail warrants, then non-warrants. And if he appears, then his bonds can be taken for appearance. For the purpose of category B and D, that is where the sentence is more than 7 years, and the economic offences, these are to be decided on merits depending upon the facts of each case. This is for the courts to see. Then comes the very category C, where there are special enactment like NDPS Act, PMLA, Companies Act, UAPA, or POSCO Act, etc., where there are stringent provisions for grant of bail, which makes the bail virtually impossible. Under the NDPA Section 37, it says without hearing the prosecution can't be granted. And second is that the court is satisfied that he is not guilty of the offence and he will not commit the offence. So this certificate is not possibly given by the court. So it makes the bail difficult in Section 37. So the object of grant of bail was discussed in Satish Chandra versus CBI in 2012, one SCC page 40. It says the object of the bail is neither punitive nor preventive. The deprivation of liberty must be considered as a punishment unless it is required to ensure that accused person will stand his trial when called upon. The court owes more than verbal respect to the principle of punishment, that the principle of punishment begins after the conviction, and every man is deemed to be innocent until duly tried and duly found guilty. So the principle of grant of bail was laid down in the old one, Kuldip Singh CBI's case versus State of Punjab, that is in 1980, when the bail, it was held that the bail is the right and jail is exception. Unluckily, it has become otherwise now. So in light of this trend which is going on today, it was necessary for the Honorable Supreme Court of India to pass this judgment and issue the directions. So the apex court in this case has also considered the right of speedy trial, considering the arrest, grant of bail, etc. The Supreme Court has observed that the right of speedy trial is a part of the Article 21 of the Constitution, as interpreted in Maneka Gandhi's case way back in 1978. The procedure to deny the personal liberty has to be reasonable, fair, and just. So section 309 I have already discussed. It is there that the trial has to be held on day-to-day basis. For that, the courts can prepare a calendar calling for sufficient number of witnesses on day one, and then some other witnesses on day 2, day 3, and so on, and complete a round of hearing covering all the witnesses. And if some of the witnesses do not appear or are not examined, then in the second round, the same procedure can be followed for day, fixing the case for day 1, 2, and 3. Though it may be opposed by some members of the bar, but they have to be convinced that it is the only way of speedy trial. I have been implementing it during my service, and I have found that even the session cases are fully tried and decided in less than 1 year. And some cases where the witnesses appear on the first or second date are decided within 3 months also, where the conviction was recorded. So starting from 3 months, any time between 1 year is a sufficient time for the decision on the session trial. For the magistrate trial, the period can be less, as the number of witnesses also less. So considering all these services, the Supreme Court has also cited the judgment of Hussain and other versus Union of India, where the judicial officers were reminded that the judicial services as well as legal services are not like any other services. They are the missions for serving the society. The mission is not achieved if the litigant who is waiting in queue does not get the turn for a long time. Then in that case, the action plan was ordered to be prepared, and the directions were issued that the bail application should be disposed of within 1 week. The magistrate trial should conclude within 2 weeks, and all the cases pending for 5 years should be decided by the year end. And in case of bail applications filed before the High Court, these are so far as possible we decided within 1 month, and criminal appeal be decided, where the accused in custody for more than 5 years are concluded at the earliest. Unluckily, despite these directions, there is still some delay in decision on the bail applications and the trials. So probably the need arose for the Supreme Court to read and discuss everything in detail again to impress upon the various courts from bottom to the top for a speedy trial. You know, in Kashmira Singh's case for state of Punjab, where the accused is in custody, certain directions were issued to release the accused on bail. So the rationale of this practice to keep the accused in custody can have no application where the court is not in a position to dispose of the appeal for 5 or 6 years. It would indeed be travesty of justice to keep a person in jail for a period of 5 or 6 years for an offense which is ultimately found not to have been committed by him. Can the court ever compensate him for the incarceration which is found to be unjustified? Would it be just at all for the court to tell a person, we have admitted your appeal because we think you have prima facie case, but unfortunately, we have no time to hear your appeal for quite a few years, and therefore, until we hear your appeal, you must remain in jail, even though you may be innocent. So that will shake the faith of the public in the judicial system. So if the appeal is admitted and the court is unable to hear the case, the accused has certain rights of grant of bail. The Supreme Court also took note of Dharmpal's case, wherein the High Court of Punjab and Haryana had laid on certain principle for a grant of bail of under trials, where it was laid down that where a convict has undergone at least 5 years of imprisonment, out of which at least 3 years is after conviction, he should be released on bail, pending the hearing of the appeal, provided he filed the application. In case of women, it was 4 years and 2 years. So now comes the most important. These are the category C, whereby under the special enactments, the grant of bail has been made impossible. Under section 37 of the NDPS Act, every offence has been made cognizable and non-bailable. The Apex Code laid down that where the offence is punishable for a term of 5 years or more, he shall be released on bail unless the public prosecutor had an opportunity to oppose the bail, or if opposed, the court is satisfied that there are reasonable grounds for believing that he is not guilty of the offence. So under section 37, the bail in case sentence is more than 5 years, the sentence is, the bail is virtually made impossible. Now, can the courts do that? On the one hand, the court cannot grant the bail, and on the other hand, it delay the trial of the cases. The Supreme Court has similarly interpreted section 20 of the Tata Act in Kartar Singh versus State of Punjab, where similar provisions were there. So therefore, the directions were issued in such cases under the special acts that where the sentence is up to 5 years, if he has undergone half of the sentence, he shall be released on bail. And if there is a fine, the amount of bail shall be 50% of that amount. If the sentence is more than 5 years, if he has already undergone half of the sentence, and the bail amount shall in no case shall be less than 50 years with 2 sureties. And in case the sentence is 10 years with a minimum fine of 1 lakh, he shall be released on bail if he has been jailed for not less than 5 years and furnished bail of rupees 1 lakh with 2 sureties of the like amount. So even in case under the NDPS Act, where he has undergone half of the sentence, the bail has been made possible by the apex court. Of course, in these cases, the accused is required to appear before the concerned police station in case of less than 5 years, within once in a month, in more than 5 years, once in a fortnight, and in case of 10 years or more, once in a week. So in case of a foreigner, the court has also considered it and say that their passport can be impounded and a certificate of assurance should be sought from the embassy that he will not leave the country and appear for the court. The court has also made it possible that in case of bail, the amount can be deposited in cash also. Of course, the economic offences have to be decided on its own merits. Now I will come to the summary of that. What are the directions? I'll only read out the important directions. The most important direction given by the court in this case is that the government of India may consider introducing a special enactment in the nature of Bail Act to streamline the grant of bails, so that the different courts do not apply different yardsticks. The further direction is that the investigating officers shall comply with the mandate of section 41 and 41A of the CRPC as given in Rajesh Kumar's case, which we have discussed. And they should, in case of non-compliance, the action has to be taken against the officer or the judicial officers. Then it requires that a standing order has to be issued as issued in the Delhi police to comply with the mandate of section 41, which contain the list of requirements of section 41, whether these are fulfilled or not, as we have discussed above. Further say that there is no need for insistence of bail application while considering the application of section 88, 170, 2004 and 2009. So then it says there is a need for strict compliance of judgment of Siddharth case, as we have discussed above. Then direction for constitution of special courts. Then finding out where the accused are not able to comply with the bail conditions, then action has to be taken under section 440. Then the compliance has to be made of mandate of section 436A, where the accused has to be released if he has undergone the certain part of the maximum sentence if he is in custody during trial. It also says that the bail application ought to be disposed of within 2 weeks, except if the provision mandate otherwise, with the exception being an intervening application. The application of anticipatory bail are expected disposed of within a period of 6 weeks. So that is necessary, considering that there is a delay in disposal of the bail application, regular bail application, and the anticipatory bail application, and there is a lot of resentment in the public and in the bar. Now, last but not the least is the implementation part. So question is, the judgment is there, how to implement it? We know that India is a vast country. Almost in every state there is a high court. Then there are so many district courts, then the courts of magistrate or munsif. So it is not possible that the judgment will come to the notice of everybody immediately. There is a need to strengthen the district judiciary and bring this judgment to the notice of the district judiciary and sanitize the magistrates and the district judges about the directions contained in this judgment, so that these can be implemented in letter and spirit. Of course, the high courts, before the high court, the judgment can be cited by the liars. The judgment can be circulated among the judges so that it comes to notice of all the judges. There are sometimes seminars can be held. There are judicial academies where the judgment can be brought to the notice of all the judges at all the levels, so that the people heave a sigh of relief so far as the arrest and bail is concerned. I'm sure that if the bail is, this judgment is implemented letter and spirit, there will be a great relief to the general public, to the bar, and it will improve our image before the world community that we are truly a democratic country where unnecessary detention is not made. So thank you very much for patiently listening me and cooperating. Thank you very much.
Thank you, sir. So nicely summed up the entire this thing. And we all know that you are so well versed with Punjabi. Just for the sake that the audience who's watching from Punjab, if you have to summarize all this directions which have been, how would you like to sum it up in Punjabi? What were the directions issued, and what is the crux of this judgment?
The crux of the judgment is that bail is the rule. Bail ek rule hai, jail exception. That is very old rule, which is of course conveniently forgotten by everybody has forgotten it. So whenever the person is in custody, तो ਉਹਦੇ ਚ ਪਹਿਲੀ ਸਭ ਤੋਂ ਪ੍ਰੋਬਲਮ ਆਉਂਦੀ ਕਿ ਉਸ ਨੂੰ ਬੇਲ ਲੈਣੀ ਬੜੀ ਔਖੀ ਹੁੰਦੀ ਹੈ। ਸੋ ਇਸ ਕਰਕੇ ਜੋ ਇਹਦੀਆਂ ਡਾਇਰੈਕਸ਼ਨਸ ਵੇਰੀਅਸ, ਇੱਕ ਤਾਂ ਸੁਪਰੀਮ ਕੋਰਟ ਨੇ ਕਿਹਾ ਕਿ ਕਿਉਂਕਿ ਡਿਫਰੈਂਟ ਕੋਰਟਸ ਜਿਹੜੀਆਂ ਨੇ ਉਹ ਡਿਫਰੈਂਟ ਪੈਰਾਮੀਟਰਸ ਜਿਹੜੀਆਂ ਉਹ ਫਾਲੋ ਕਰਦੀਆਂ ਨੇ, ਕੋਈ ਕੋਰਟ ਬੇਲ ਦਿੰਦੀ ਹੈ, ਇਸ ਕਰਕੇ ਇੱਕ ਬੇਲ ਐਕਟ ਜਿਹੜਾ ਬਣਾਇਆ ਜਾਵੇ ਜਿਹੜਾ ਕਿ ਸਾਰੇ ਬੇਲ ਮੈਟਰ ਨੂੰ ਸਟ੍ਰੀਮਲਾਈਨ ਕਰ ਦੇ ਕਿ ਕਿਹਨਾਂ ਕਿਸ ਬੇਲ ਕਰਨੀ ਹੈ, ਕਿਹਨਾਂ ਚ ਨਹੀਂ ਕਰਨੀ ਔਰ ਕਿਸ ਤਰ੍ਹਾਂ ਕਰਨੀ ਹੈ। ਜਿਵੇਂ ਕਿ 7 ਸਾਲ ਤੋਂ ਥੱਲੇ ਘੱਟ ਸਜ਼ਾ ਵਾਲੇ ਕੇਸ ਨੇ, ਉਹਨਾਂ ਦੇ ਵਿੱਚ ਆਰਡੀਨਰਲੀ ਬੇਲ ਹੋ ਜਾਣੀ ਚਾਹੀਦੀ ਹੈ। ਬਟ ਅਨਲੱਕੀਲੀ ਅਸੀਂ ਦੇਖਿਆ ਕਿ ਕਈ ਐਸੇ ਕੇਸ ਹੈਗੇ ਹੈ ਜਿਨ੍ਹਾਂ ਚ ਕਿ ਉਹ ਜੋ ਹੈ ਹਾਈ ਕੋਰਟ ਤੱਕ ਬੇਲ ਆ ਰਹੀ ਹੈ। ਦੈਟ ਮੀਨਸ ਕਿ ਉਹ ਡਿਸਟ੍ਰਿਕਟ ਜੱਜ ਨੇ ਵੀ ਬੇਲ ਜਿਹੜੀ ਹੈ ਉਹ ਡਿਸਮਿਸ ਕਰਤੀ ਹੈ। ਸੋ ਉਹਦਾ ਰਿਜ਼ਲਟ ਇਹ ਹੋਇਆ ਕਿ ਜੇਲਾਂ ਭਰ ਗਈਆਂ ਸਾਰੀਆਂ, ਬੰਦੇ ਅਨਸੈਸਰੀ ਸਫਰ ਕਰੀ ਜਾ ਰਹੇ ਨੇ, ਜੇਲਾਂ ਛੱਡੀ ਜਾ ਰਹੇ ਨੇ। ਤੋ ਜਿਨ੍ਹਾਂ ਕੇਸਾਂ 'ਚ ਟ੍ਰਾਇਲ ਚੱਲਣਾ ਹੈ ਉਹਨਾਂ 'ਚ ਸਜ਼ਾ ਉਹਨਾਂ ਨੂੰ ਪਹਿਲਾਂ ਹੀ ਭੁਗਤ ਲੈਂਦੇ ਆ ਉਹ ਬੰਦੇ। ਉਹਨਾਂ ਨੂੰ ਜਿਹੜੀ ਆ ਉਹ ਸਜ਼ਾ ਹੋਣ ਤੋਂ ਪਹਿਲਾਂ ਹੀ ਉਹ ਸਜ਼ਾ ਭੁਗਤ ਲੈਂਦੇ ਨੇ। ਤੇ ਕਈ ਕੇਸਾਂ 'ਚ ਮੈਜਿਸਟਰੇਟ ਲਾਈਟਲੀ ਕਹਿੰਦੇ ਨੇ ਤੁਸੀਂ ਐਂ ਕਰੋ ਕਨਫੈਸ਼ਨ ਕਰ ਲਓ, ਅਸੀਂ ਤੁਹਾਨੂੰ ਆਲਰੇਡੀ ਅੰਡਰਗਰਾਊਂਡ ਕਰ ਦਿੰਦੇ ਹਾਂ। ਸੋ ਉਹ ਕਨਸੈਪਟ ਇੱਕ ਬਣ ਗਿਆ ਸੀਗਾ, ਉਹ ਬਹੁਤ ਗਲਤ ਹੈ। ਦੇਖੋ ਇੱਕ ਬੰਦੇ ਦਾ ਟ੍ਰਾਇਲ ਹੁੰਦਾ ਹੈ, ਹੀ ਮੇ ਬੀ ਗਿਲਟੀ, ਇਹਦਾ ਫੈਸਲਾ ਤਾਂ ਬਾਅਦ ਚ ਹੋਣਾ ਹੈਗਾ। ਸੋ ਵੀ ਕੈਨ ਨਾਟ ਪੁਨਿਸ਼ ਏ ਪਰਸਨ ਬਿਫੋਰ ਦੀ ਟ੍ਰਾਇਲ। ਟ੍ਰਾਇਲ ਤੋਂ ਪਹਿਲਾਂ ਉਹਨੂੰ ਪਨਿਸ਼ਮੈਂਟ ਨਹੀਂ ਦੇ ਸਕਦੇ। ਇਸ ਕਰਕੇ ਇਨ ਆਰਡੀਨਰੀ ਕੇਸਿਸ ਦੀ ਬੇਲ ਸ਼ੁੱਡ ਬੀ ਰੂਲ ਐਂਡ ਜੇਲ ਸ਼ੁੱਡ ਬੀ ਐਕਸੈਪਸ਼ਨ। ਫਿਰ ਇੱਕ ਜਿਹੜੀਆਂ ਡਾਇਰੈਕਸ਼ਨ ਹੈ ਰਣੇਸ਼ ਕੁਮਾਰ ਕੇਸ 10 ਕੇਸ ਕੀ ਮੈਜਿਸਟਰੇਟ ਨੂੰ ਡਾਇਰੈਕਸ਼ਨ ਦਿੱਤੀ ਵੀ ਇੰਨੇ ਚ ਫੈਸਲਾ ਕਰੋ। ਹੁੰਦਾ ਕੀ ਹੈ ਕਿ ਲੋਅਰ ਕੋਰਟ ਦੇ ਵਿੱਚ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਦਿੱਤੀ ਪੈਂਡਿੰਗ ਰਹਿੰਦੀ ਹੈ, ਕਿੰਨੀ ਚਿਰ ਉਹ ਬੰਦਾ ਕਸਟਡੀ 'ਚ ਹੈ, ਉਹ ਡੇਟਾਂ ਪਈ ਜਾ ਰਹੀਆਂ ਨੇ, I don't know what is the reason why it is not decided. Anticipatory bail है वो pending रहती है. Same is the petition in the High Court. Liars की complaint रहती है कि bail application anticipatory file करती, notice हो गया 6 महीने साल decide ही नहीं होती. वो बंदे दे जे arrest stay नहीं हुई तो वो भज्जा फिरदा रहंदा हैगा. Illegally वो छुप के रहंदा पुलिस तो भी पुलिस ना पकड़ लवे. So ਇਹ ਜ਼ਰੂਰੀ ਹੈ ਕਿ ਜਿਹੜੀ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਰੈਗੂਲਰ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਤੇ ਐਂਟੀਸਪੇਟਰੀ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਹੈ ਉਹ ਇੱਕ ਟਾਈਮ ਬਾਉਂਡ ਮੈਨਰ ਦੇ ਵਿੱਚ ਡਿਸਾਈਡ ਹੋ ਜਾਏ ਦਿਸ ਵੇ ਔਰ ਦੈਟ ਵੇ ਤਾਂ ਕਿ ਬੰਦੇ ਨੂੰ ਪਤਾ ਲੱਗ ਜਾਏ ਕਿ ਉਹਨੇ ਕਿਹੜੀ ਰੈਮਡੀ ਅੱਗੋਂ ਬੇਲ ਕਰਨੀ ਉਹ ਕਰ ਲਵੇ ਸੋ ਇਸ ਕਰਕੇ ਉਹਨਾਂ ਨੇ ਦਿੱਤੀਆਂ ਨੇ ਕਿ ਪਹਿਲੀਆਂ ਜੱਜਮੈਂਟ ਵੀ ਜਿਹੜੀਆਂ ਦਿੱਤੀਆਂ ਸੀ ਉਹ ਉਹਨਾਂ ਨੇ ਰੀਟਰੇਟ ਕੀਤੀਆਂ ਨੇ ਸਿਧਾਰਥ ਕੇਸ ਦਾ ਰਵੇਸ਼ ਕੁਮਾਰ ਕੇਸ ਔਰ ਜਿਹੜੇ ਸੈਕਸ਼ਨ 40 ਤੇ 41 ਦੀ ਕੰਪਲਾਇੰਸ ਹੈ ਸੁਪਰੀਮ ਕੋਰਟ ਨੇ ਕਿਹਾ ਕਿ ਤੁਸੀਂ ਇੱਕ ਚੈੱਕਲਿਸਟ ਬਣਾਓ ਸੈਕਸ਼ਨ 41 ਦੀ ਵੀ ਕੀ ਇਹ ਅਰੈਸਟ ਜ਼ਰੂਰੀ ਹੈ ਕੀ ਇਹ ਬੰਦਾ ਭੱਜ ਸਕੂਗਾ ਕਿੱਦਾਂ ਦੀ ਪੋਜੀਸ਼ਨ ਹੈ ਕਾਮ ਸ਼ਰੀਫ ਬੰਦਾ ਹੁੰਦਾ ਉਹਨੂੰ ਅਰੈਸਟ ਕਰਕੇ ਲੈ ਆਉਂਦੇ ਨੇ ਵਿਚਾਰਾ ਉਹਨੂੰ ਪਤਾ ਨਹੀਂ ਹੁੰਦਾ ਕਈ ਲੇਡੀਜ਼ ਹੈ ਉਹਨਾਂ ਨੂੰ ਉਹ ਡੋਰੀ ਕੇਸ ਹੁੰਦੇ ਆ ਜੀ ਉਹ ਸਾਡੇ ਤੋਂ ਦਾਜ ਮੰਗਦੇ ਆ ਜੀ ਫਲਾਨ ਕਰਦੇ ਅਰੈਸਟ ਕੀਤਾ ਅਰੈਸਟ ਕਰਕੇ ਕਰਤਾ ਈਵਨ ਇਨ ਕੰਪਲੇਂਟ ਕੇਸ ਦੇ ਵਿੱਚ ਮੇਰੇ ਦੇਖਣ ਚ ਆਇਆ ਕਿ ਕੰਪਲੇਂਟ ਕੇਸ ਹੈ ਅਕਿਊਜ਼ ਇਨੋਸੈਂਟਲੀ ਕਿਤੇ ਅਪੀਅਰ ਹੋ ਗਏ ਮੈਜਿਸਟ੍ਰੇਟ ਨੇ ਪਕੜ ਕੇ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਦਾ ਨੋਟਿਸ ਕੀਤਾ ਤੇ ਉਹ ਬੰਦੇ ਬੁੜੀਆਂ ਜਿੰਨੇ ਸਾਰੇ ਵਿੱਚੇ ਅਨਮੈਰਿਡ ਗਰਲਸ ਸਾਰੀਆਂ ਨੂੰ ਅੰਦਰ ਭੇਜਤਾ ਸੋ ਦੈਟ ਇਜ਼ ਨਾਟ ਦੀ ਰਿਕੁਆਇਰਮੈਂਟ ਉਹਨਾਂ ਨੂੰ ਸਮਝ ਜਾਣੇ ਨੇ ਫੰਸ ਯੂ ਹੈਵ ਟੂ ਸਮਨ ਭੇਜ ਤੇ ਅਪੀਅਰ ਹੋ ਗਏ ਯੂ ਹੈਵ ਟੂ ਇਨਸ਼ੋਰ ਕਿ ਉਹਦੀ ਪ੍ਰੈਜ਼ੈਂਸ ਜਿਹੜੀ ਉਹਨਾਂ ਨੇ ਟ੍ਰਾਇਲ ਦੇ ਵਿੱਚ ਪ੍ਰੈਜ਼ੈਂਟ ਹੋਣਾ तो वहाँ से बेल बॉन्ड ले लो इट इज नॉट अ बिग थिंग प्रॉब्ली ਮੈਨੂੰ ਲੱਗਦਾ ਕਿ ਅਫੀਸਰ ਸ਼ਿਕਾਇਤਾਂ ਤੋਂ ਡਰਦੇ ਨੇ ਕਿ ਕੋਈ ਸ਼ਿਕਾਇਤ ਕਰ ਦੇਗਾ ਤੇ ਉਹ ਸਾਡੇ ਤੇ ਪਤਾ ਨਹੀਂ ਕੀ ਹੋ ਜਾਏਗਾ ਮੇਰੇ ਖਿਆਲ 'ਚ ਸਾਰਾ ਇਹ ਇੱਕ ਦਿਮਾਗ ਦਾ ਸੈਲਫ ਕ੍ਰੀਏਟਡ ਫੀਅਰ ਹੈ ਮੈਂ ਸਾਰੀ ਸਰਵਿਸ ਕੀਤੀ ਹੈ ਮੈਨੂੰ ਕਦੀ ਵੀ ਮੇਰੇ ਜੁਡੀਸ਼ੀਅਲ ਆਰਡਰ ਕਰਕੇ ਕਦੀ ਪ੍ਰੋਬਲਮ ਨਹੀਂ ਆਈ ਮੈਂ ਜੁਡੀਸ਼ੀਅਲ ਆਰਡਰ ਪਾਸ ਕੀਤਾ ਅਕੋਰਡਿੰਗ ਲਾ ਕੀਤਾ ਦੈਨ ਆਈ ਵਿਲ ਸਟੈਂਡ ਬਾਈ ਇਟ ਠੀਕ ਹੈ ਮੈਂ ਪਾਸ ਕੀਤਾ ਲਾ ਰਿਕੁਆਇਰਸ ਇਟ ਤੁਸੀਂ ਮੈਂਸ਼ਨ ਕਰਦੇ ਸੈਕਸ਼ਨ 41 ਦੀ ਰਿਕੁਆਇਰਮੈਂਟ ਆ ਸੁਪਰੀਮ ਕੋਰਟ ਜਜਮੈਂਟ ਆ ਮੈਂ ਇਹਦੀ ਬੇਲ ਕਰ ਰਿਹਾ ਉਹਦੇ 'ਚ ਕੀ ਪ੍ਰੋਬਲਮ ਹੈਗੀ ਹੈ ਵੱਧ ਤੋਂ ਨੋਟਸ ਬਣਾ ਲਓ ਉਹ ਅੱਜ ਕੱਲ੍ਹ ਤਾਂ ਕਾਪੀ ਪੇਸਟ ਹੀ ਕਰਨੇ ਹੁੰਦੇ ਨੇ ਉਹ ਕਾਪੀ ਪੇਸਟ ਕਰਕੇ ਉਹਦੇ 'ਚ ਹੋ ਸਕਦਾ ਹੈਗਾ ਜੇ ਇੰਪਲੀਮੈਂਟ ਜਜਮੈਂਟ ਇੰਪਲੀਮੈਂਟ ਹੋ ਜਾਂਦੀ ਹੈ ਤੇ ਇਹਦੇ ਨਾਲ ਬਹੁਤ ਵੱਡੀ ਰਿਲੀਫ ਹੋਏਗੀ ਇੱਕ ਲਾਰਜ ਚੰਕ ਆਫ ਜਿਹੜੇ ਅੰਡਰ ਟ੍ਰਾਇਲਸ ਹੈ ਜੇਲ੍ਹ ਤੋਂ ਬਾਹਰ ਆ ਜਾਣਗੇ ਜੇਲ੍ਹਾਂ ਨੂੰ ਰਿਲੀਫ ਮਿਲ ਜੇਗੀ ਔਰ ਦੂਜੀ ਗੱਲ ਇਹ ਹੈ ਕਿ ਜਿਹੜੀ ਇੰਸਿਸਟੈਂਸ ਉਹਨਾਂ ਦੀ ਕੋਰਟ ਦੀ ਹੈ ਕਿ ਜਿਹੜੇ ਕੇਸਿਸ ਪੈਂਡਿੰਗ ਨੇ ਅਪੀਲਾਂ 'ਚ ਉਹਨਾਂ ਦਾ ਜਲਦੀ ਫੈਸਲਾ ਕਰੋ ਇਹ ਨਹੀਂ ਹੋਵੇ ਕਿ ਅਪੀਲ ਜੇ ਫਾਈਲ ਹੋ ਗਈ ਤੇ ਉਹਦੇ ਲਾਈਫ ਟਾਈਮ ਵਿੱਚ ਡਿਸਾਈਡ ਹੀ ਨਹੀਂ ਹੋਣੀ ਉਹਦੇ ਲਈ ਡਿਫਰੈਂਟ ਸਟੈਪਸ ਲੈਣੇ ਪੈਣਗੇ ਜੁਡੀਸ਼ਰੀ ਨੂੰ ਇਨ ਕੰਸਲਟੇਸ਼ਨ ਵਿਦ ਦੀ ਅਦਰ ਅਥਾਰਟੀਜ਼ ਕਿ ਉਹਨਾਂ ਨੂੰ ਕਿਵੇਂ ਸਪੀਡੀ ਟ੍ਰਾਇਲ ਕਰਨਾ ਹੈ ਦੇ ਹੈਵ ਟੂ ਡਿਸਾਈਡ ਦੈਮਸੈਲਫ ਤੋ ਇਸ ਤਰ੍ਹਾਂ ਦਾ ਹੈ ਤੋ ਬੇਲ ਦੇ ਬਾਰੇ ਚ ਬੇਲ ਬੌਂਡਸ ਕਿਸ ਤਰ੍ਹਾਂ ਲੈਣੇ ਨੇ ਉਹਨਾਂ ਦੀ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਦੀ ਜ਼ਰੂਰਤ ਹੈ ਨਹੀਂ ਹੈ ਕਈ ਕੇਸਾਂ ਜਿੱਥੇ ਅਕਿਊਜ਼ ਦੀ ਕਸਟਡੀ ਮੋਰ ਦੈਨ ਰਿਕੁਆਇਰਡ ਪੀਰੀਅਡ ਹੋ ਗਈ ਹੈ 60 ਡੇਜ਼ ਜ਼ਿਆਦਾ ਹੋ ਗਈ ਹੈ ਬੇਲ ਆਪਣੀ ਜ਼ਰੂਰਤ ਹੀ ਨਹੀਂ ਹੈ ਕਿ ਉਹਦੇ ਤੁਸੀਂ ਯੂ ਕੈਨ ਸਟੇਟ ਵੇ ਡਿਸਾਈਡ ਕਿ ਇਹਦੇ 60 ਡੇਜ਼ ਹੋ ਗਿਆ ਆਈ ਕਾਂਟ ਰਿਮਾਂਡ ਦਾ ਕਰ ਹੀ ਨਹੀਂ ਸਕਦੇ ਤੁਸੀਂ ਉਹਦੀ ਜਿਹੜੀ ਹੈ ਉਹ ਬੇਲ ਕਰਨੀ ਹੁੰਦੀ ਹੈ ਸਮਨ ਕੇਸ ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਉਹ ਕੰਪਲੇਂਟ ਕੇਸ 'ਚ ਅਪੀਅਰ ਹੋਏ ਉਹਨੂੰ ਠੀਕ ਆ ਵੀ ਬੌਂਡ ਨੋ ਨੀਡ ਆਫ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਤੁਸੀਂ ਬੇਲ ਬੌਂਡ ਦੇ ਦਿਓ ਦੇ ਕੇ ਜਾਓ ਤੁਸੀਂ ਯੂ ਕੈਨ ਪਾਸ ਦੀ ਆਰਡਰ ਉਹਦੇ ਵਿੱਚ ਡਰਨ ਦੀ ਕੋਈ ਗੱਲ ਨਹੀਂ ਹੈਗੀ ਡਰ ਜਿਹੜਾ ਹਮੇਸ਼ਾ ਮਨ 'ਚ ਹੁੰਦਾ ਤੇ ਉਹ ਮਨ 'ਚੋਂ ਡਰ ਵੀ ਜਿਹੜਾ ਉਹ ਕੱਢਣਾ ਪਏਗਾ ਕੋਈ ਕੁਛ ਨਹੀਂ ਕਹਿੰਦਾ ਹੈਗਾ ਐਵੇਂ ਤੁਸੀਂ ਬੈਠੇ ਡਰੀ ਜਾਓ ਚੇਅਰ ਤੇ ਬਹਿ ਕੇ ਉਹ ਕੋਈ ਗੱਲ ਨਹੀਂ ਹੈ ਸੋ ਹਾਈ ਕੋਰਟ ਜਿਹੜੀ ਆ ਉਹ ਸਹੀ ਅਫਸਰ ਨੂੰ ਕਦੀ ਵੀ ਕੁਛ ਨਹੀਂ ਕਹਿੰਦੀ ਗੀ ਕੋਈ ਪ੍ਰੋਬਲਮ ਹੁੰਦੀ ਜੇ ਕਿਸੇ ਦੇ ਮਨ 'ਚ ਚੋਰ ਹੋਵੇ ਵੱਖਰੀ ਗੱਲ ਹੈ ਬਟ ਆਈ ਥਿੰਕ ਕਿ ਜੇ ਜਜਮੈਂਟ ਸਾਰੀ ਇੰਪਲੀਮੈਂਟ ਹੋ ਜਾਂਦੀ ਹੈ ਤੇ ਖਾਸ ਕਰਕੇ ਡਿਸਟ੍ਰਿਕਟ ਜੁਡੀਸ਼ਰੀ ਦੇ ਕਾਰਨ ਕਈ ਕੇਸ ਜਿਹੜੇ ਪੈਂਡਿੰਗ ਹੈ ਅਨਸੈਸਰੀ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਡਿਸਟ੍ਰਿਕਟ ਕੋਰਟ ਜਾ ਰਹੀਆਂ ਹਾਈ ਕੋਰਟ ਜਾ ਰਹੀਆਂ ਬੰਦ ਹੋ ਜਾਣਗੀਆਂ ਤੇ ਕੋਰਟਾਂ ਨੂੰ ਬੜੀ ਵੱਡੀ ਰਿਲੀਫ ਮਿਲੇਗੀ ਉਹ ਹਾਈ ਕੋਰਟ ਤੇ ਸੁਪਰੀਮ ਕੋਰਟ ਦਾ ਕਾਫੀ ਟਾਈਮ ਦਾ ਬੇਲ ਐਪਲੀਕੇਸ਼ਨ ਆ ਡਿਸਾਈਡ ਕਰਨ ਤੇ ਨਿਕਲ ਜਾਂਦਾ ਹੈਗਾ ਮੇਨ ਕੇਸ ਤਾਂ ਟੇਕਅਪ ਹੀ ਨਹੀਂ ਕਰ ਪਾਉਂਦੇਗੇ ਅਨਸੈਸਰੀ ਜਿਹੜੇ ਮੈਟਰਸ ਹੈਗੇ ਆ ਜਿਹੜੇ ਕਿ ਮੈਜਿਸਟ੍ਰੇਟ ਲੈਵਲ ਤੇ ਜਾਂ ਵੱਧ ਤੋਂ ਡਿਸਟ੍ਰਿਕਟ ਲੈਵਲ ਤੇ ਡਿਸਾਈਡ ਹੋ ਜਾਣੇ ਚਾਹੀਦੇ ਉਹ ਹਾਈ ਕੋਰਟ ਜਾਂ ਸੁਪਰੀਮ ਕੋਰਟ ਜਾਂਦੇ ਨੇ ਉਹ ਨਹੀਂ ਆਉਣਗੇ ਸੋ ਦਿਸ ਇਜ਼ ਦੀ ਕਰਕਸ ਆਫ ਦੀ ਜਜਮੈਂਟ ਵਿਕਾਸ ਆਰ ਯੂ ਸਟਿਲ ਦੇਅਰ
Yes, sir. Somehow somebody had called up. Yes, sir. So it has been nicely summed up. I feel that those who are from Punjab and those who know Punjabi will also understand how the crux has been taken. And thank you, everyone. Stay safe, stay blessed. And we are once again thankful to Justice Kuldip Singh for sparing his time on a day where there's so much of rain. And he has just rained with his knowledge, which everybody will cherish. The entire crux has been explained so beautifully that people will understand the judgment and such a good man.
Because I can see on the screen my old class fellow and old friend, Mr. Sunny. So I can see I can recognize him after a long time. So he was my class fellow as an old friend. So I've seen him after a long time with gray hairs and gray mustaches. So I hope I will see you physically one day.
So I have muted him.
Oh, it is a rainy day. That is a gift from the nature on a rainy day to see an old friend.
So nice, sir. So nice, sir.